Jessica, can you still not hear us?
So I can hear a little bit, but it is very muted. Is it just me? I have
mean,
my volume up
yeah,
100%.
Commissioner and Judge can hear us, it seems.
Thank you for your patience. We are now live on YouTube and recording on WebEx.
Okay, good morning and welcome to the June 14th, 2024 meeting of the New York State Commission on Forensic Science. At this time, I will take attendance to establish a quorum. Please respond present when I call on you. Dr. Dooley.
Present.
Mr. Fitzpatrick.
Present.
Judge Mazzarelli.
Present.
Dr. Chithalin.
Present.
Dr. Bufalino.
Present.
Ms. Goldthwait.
Present.
Ms. Rao.
Present.
Mr. Epstein.
Present.
Mr. Castro.
Present.
Dr. Marciano.
Present.
Ms. Schmitz.
Present.
Dr. Wiley.
Present.
Thank you, and including myself, we have established a forum. I received a request from the Onondaga County Center for Forensic Sciences Laboratory Director, Renee Ho, and Senior Firearms Examiner, Justine Cresso, to speak on the firearms examination results discussed at the March meeting. Is there any discussion regarding this request? Do I have a motion to approve this request and discuss this under old business?
So move.
Second.
Okay, do I have a second? Thank you. All in favor, please say aye.
Aye.
Any opposed? Any abstentions? All right, the motion carries. At this point, we will approve the agenda for today's meeting. Is there any discussion regarding the agenda? Okay. Do I have a motion?
I move.
Thank you. Do I have a second?
Second.
Great. I have a second. Okay, so all in favor, please say aye.
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 Any opposed? Any abstentions? Thank you so much. That motion carries. Okay. You have also received a draft of the minutes from the March 15th, 2024 meeting. Are there any questions or comments about those minutes? Okay. Do I have a motion to approve those minutes?
Motion to approve.
Thank you so much. Do I have a second?
Second.
Great. All in favor, please say aye.
Aye.
Any opposed? Any abstentions?
Abstain.
Okay. I didn't see who that was, but Jill, you
Dr.
told me.
Wiley.
Dr. Lilly.
Okay, thank you. Thank you so much. The motion carries. Okay. That was the March 15th. Okay. All right. The next item on the agenda is executive session. So I have a motion to go into executive session to discuss matters relating to a current investigation or matters that may lead to the appointment, promotion, demotion, discipline, or suspension of a particular person.
I move.
Thank you. Do I have a second?
Second.
Thank you. All in favor, please say aye.
Aye.
Okay. Any opposed?
Yes.
Opposed.
Thank you. One opposed. Any abstentions?
Two opposed.
Sorry, Commissioner, 2 opposed. I also oppose.
Okay, so we have 2 opposed. Do we have any abstentions? No? Okay. Then that motion carries. At this point, I'm sorry, Jill.
That's okay.
This is-
At this point, if you're not a commission member or staff, you will be expelled from the virtual, no, you will stay on the virtual meeting. It will be paused. You can stay there. And the pausing will also happen on YouTube at this time. The streaming will resume when we're back in executive session. Everyone who's not DCJS staff or commission member, please leave the room. And we'll call you back in when we are done. Thank you.
So do we minimize or go out?
So you're gonna go on the other link for the executive session, everyone who's a commission member online.
And Cheyenne.
Okay.
And Cheyenne, yes, our council.
So we have to leave this one because we can't do 2
Yep,
at the
exit
same
out of
time.
this one and then go to the executive link. Thank you.
Like the place, what?
Yes.
Cheyenne Burke is a newer, Jessica, you're 917?
Yes. Do you want to give her whole number out or?
I just-
No.
We can't see them.
I know we're waiting, we're back streaming on YouTube though, right, Catherine?
Thank you for your patience. We are now live on YouTube and recording on WebEx.
Go ahead, Commissioner.
Okay, we are back in open session. No action was taken during executive session, but I'm gonna, since I
Not
am
true.
remote, I'm gonna, nope, not true. Sorry. Let's start
I'll
over.
take it.
We are back in open session. I'm gonna turn it over to Dr. Dooley to report on that, on the executive session, and also to step in as chair since I am remote today. So Dr. Dooley, please walk us through.
Okay, so during executive session, action was taken to form a working group that will further review an ongoing complaint regarding the New York City Office of Chief Medical Examiner. We have several informational updates today and a couple of accreditation votes, so we'll get going. We definitely have a full agenda. The first item up is the Monroe County Forensic Toxicology Lab. There is a vote required in this matter, and we do have members available to speak from the lab who are present here in Albany. In March, the laboratory underwent a full ANAD assessment, and there was one nonconformance. The laboratory has remediated that nonconformance, and ANAD has granted accreditation based on the results of the assessment. Are there any questions for the lab?
I have one.
One.
And
Just a second, she'll step to this.
thank you.
And just a reminder, we're having some audio challenges, so if you could talk to the screen and not to the questioner, that would be helpful. Thank you.
Just pretend like you're in
We won't
court
be
and you're looking at the jury. They're the jury.
They're the jury.
Okay, go ahead.
It's indicated in your report that all stakeholders were notified. Give me a sense of who that would have been.
Sorry, are we talking about the
accreditation?
No, we're talking about the report out on the identification of the drugs being the wrong identification of the drug.
No, that's the next section. We're only talking about their assessment activity.
Unrelated to the,
Unrelated, we'll get to that.
okay, I'll hold off on that.
So do we have any questions regarding the assessment activity and the non-conformance, but they're granted full accreditation? No questions? Thank you. Do I have a motion to issue a full renewal of the New York State accreditation to the Monroe County Office of Medical Examiner Forensic Toxicology Laboratory concurrent with its ANAB accreditation?
So moved.
Michelle has made the motion. Do I have a second?
Second.
Fitz has seconded the motion. All those in favor, please say aye.
Aye.
Aye. Any opposed? Any abstentions? With that, the motion carries. Next up,
Congratulations.
yes, congratulations for that feat. Good job. Suffolk County Medical Examiner Toxicology Lab is next. We do have members from the lab available to speak virtually, and there is a vote required for this. In March, the lab underwent a full ANAB assessment, and there was one non-conformance. The laboratory has remediated that non-conformance, and ANAB has granted accreditation based on the results of the assessment. Do we have any questions for the laboratory regarding their full accreditation? Jessica's waving her hand, and I see you and I acknowledge you. Yes.
Thanks, appreciate it. Can I go ahead or?
Yep, go
One
ahead.
second, please.
Oh, we're just
Oh,
gonna,
thank you.
sorry, bring them up. Makes sense to bring the folks up. You're not just questioning me, you're gonna question them. so. They're remote, yes.
They are currently not on. Give me 1 second and I will email.
Oh, boy.
Catherine? Catherine,
Go ahead.
do you see Suffolk County or Inga? They were all gonna be in the same room together, so if you see either of those names, you can pull them up.
There we go.
Okay. They are on. Can you hear us, Inga and friends?
Yes, we can hear you.
Perfect. Okay, go ahead.
Good morning. Apologies in advance. I'm having some audio issues, so hopefully I'll catch everything you say. I just had a question about the nonconformity, which I understand was remediated. And I did have a question about your quality or your SOPs. But my understanding, and please correct me if I'm wrong, about the nonconformity is that the lab was not keeping records of conversations you would have with customers, either, I guess, prosecutors or police officers, or I suppose defense attorneys. You would note the fact that a conversation had occurred, but you wouldn't note the substance of it. Do I have that correct?
No, we were noting that the conversations were taking place and that what was discussed as far as if we were giving results, but not specifics about what results or what we were saying. So they wanted us to be a little more detailed in that aspect. So that's what we added in.
And you changed your SOPs, and I think I saw in our materials you also provided us with examples as part of your monitoring process and your corrective action, correct?
That's correct, yes.
Okay. Were you keeping email correspondence, or is that just a thing your lab wasn't doing at all? I understand, like, telephone conversations. What about emails?
Yes, if there was emails going back, for instance, between a pathologist and postmortem supervisor, yes, we were keeping those emails as well.
And they would be turned over as part of discovery in the case file?
Right, they go into the case file and then it gets scanned into discovery as well.
Okay, great. Thank you.
You're welcome.
The other question I had is you did helpfully provide to us your SOPs on reporting tox results, and I understand that you're following ISO and the NICLAC, New York standardization for reports. I do have a few questions about some of the things you indicated you don't include on the report, because I just don't understand why, even though you may be in conformance, right, with the requirements of ISO and NICLAC. The date of testing, at least I think with DUIs, whether there was a deviation from a method, measurement uncertainty except for DUIs, and then items not tested. Please correct me if I'm wrong, but I think all of those things are not included in your report. First, let me make sure I have that right. Is that true?
I believe so, yes. And they were part of our memorandum of agreement that was sent out with all of our clients.
I did see that. So there was an MOU between you and your customers. But can you explain why you wouldn't include the date of the testing performed?
Well, because it could vary, because there's multiple tests done, and to have all the tests with different dates, it gets very complicated and convoluted. So we felt that that was something that's included in the test, the case file, and can be seen in discovery anyway, and wasn't necessary to be put on the report.
So it's a trade-off between readability, comprehensibility, and information.
Yeah, because there's so many multiple things that go into it, it's just easier for everyone. It makes it simpler to track.
Okay, but all that information's in the fuller case
It's
file.
all available in the case file, yes.
Could you explain what a deviation from the method is in this context?
Possibly if we had received a kit that was not sealed, for instance, is something that we would notify the DA that we didn't receive the kit. We'd have a letter that went out to them to sign. That would be a deviation from what we have in our SOP, but we would have documentation of that happening, and it would also be put into the case file.
But not in the report.
Correct. Or now we would put a little statement at the bottom says, you know, in the comment section, would say deviation, you know, a kit not sealed or something like that. And then that letter would be part of the case file going forward.
So there would be some indication on the report.
In that instance, there would.
Okay. So some instances, yes and no. And what about measurement uncertainty? There seems to be a growing consensus in the community that reporting measurement uncertainty in a report is important. Maybe it's not universal, but can you just explain why you wouldn't report measurement uncertainty except for DUI on the report?
We're not required to as far as the drugs go, but for alcohols we do.
But why don't you?
It's just not something that we have been required to do, and we do create those measurement uncertainties for all drugs. We have them available if requested. We don't put them on the report.
Yeah. It just, you know, like I said, it seems like there's a growing consensus that it's important in order to understand the limitations of the test and to fully appreciate the meaning of the results, that you have to have a sense of the measurement uncertainty. But obviously it's included in the case report. Sorry, not the report, the case file. Measurement uncertainty is in the case file?
Yes. No, we don't put it in the case file, but we have it available if requested.
It's not in the case file either?
No, it's in our QC.
Is there any, is there any indication on the report that measurement uncertainty has been calculated and is available at the laboratory, but is not contained in the case file?
Not for the drugs, no. Only for alcohol.
That seems scientifically unsupportable. I'm not a scientist, but this is in accordance with NICLAC?
For toxicology, yes.
Oh, okay. Okay. What about items not tested? Is that also not included on your report?
Correct, because we received several items for a single case. Again, it would be very convoluted to put them all on the report, so we only put the sample that was actually tested.
Is that information in the case file?
Absolutely.
Okay, so a list of items received and what it would be clear to someone receiving the case file what items were tested and were not tested.
That's correct.
Okay, all right, thank you.
You're welcome.
Michelle?
Yeah, I just wanted to follow up about the measurement uncertainty. It's not in the case file, but it's in your SOP, and those are considered the non-case specific documents you would provide for discovery, correct, if they were requested?
I'm sorry, you broke up. I couldn't hear you there.
That's okay. If discovery is requested, often they can request your SOPs, and that's where they would see the measurement uncertainty.
Well, they would have to ask us specifically for the specific drug that we're looking for. It's not individually in the SOP, but the request could be placed for it, and we would provide it to them at that point.
Okay, perfect.
Is there any notation, though, in the report that can be requested? Would you consider adding that? If not,
we
right
don't
there,
have we don't have it on there
I'm
at the
sorry,
time.
go ahead.
Yeah, we don't have it on there right now, but it's something we would possibly consider.
Yeah, I'm thinking for the defense community, often we don't know to ask for something unless there's a flag to ask for it. And I understand, as you stated earlier, that there is a trade-off between overloading a report with information, which makes it incomprehensible and doesn't do anyone any good, but it also providing enough information to at least signal the reader of the report that there's additional information that could be important. So that would be my suggestion. But yeah, I would appreciate if you consider it for sure. Thank you.
Do I have a motion to issue the full renewal for New York State accreditation to the Suffolk County Medical Examiner Toxicology Laboratory concurrent with its ANAB accreditation? Michelle has made the motion. Do I have a second? Ben has seconded the motion. All in favor, please say aye.
Aye.
Any opposed? Any abstentions? With that, the motion carries. Thank you.
Congratulations.
I tried to shoot some stuff on there, guys, sorry, online. So go microphone. Now, we may get too much background noise from this setting, but whatever, we'll figure it out. It's a mess. Next up, for informational purposes only, no vote is required. We have the Erie County Central Police Forensic Services Forensic Laboratory. In April, ANAB conducted a surveillance activity. There was one finding related to the FBI QIS testing document. It was laboratory activities must be carried out in a way that meets the requirements of regulatory authorities with the FBI QIS standard. The laboratory has remediated their finding, and ANAB has issued a continuation of accreditation based on the results of the assessment activity. Do we have any questions for the laboratory? We do have some representatives available virtually. Hearing nothing, okay, we'll move on to the Erie County Medical Examiner's Office of Forensic Toxicology Laboratory. This is for informational purposes. No vote is required. And we do have members to speak from the lab available virtually if there are any questions. In April, ANAB conducted a surveillance assessment activity. There were no findings. ANAB has issued a continuation of accreditation based on the results of the assessment activity. Does anyone have any questions? Moving on, Monroe County Crime Lab. For informational purposes, no vote is required. We do have a representative available to speak from the lab. In April, ANAB conducted a surveillance assessment activity. There was one finding. The laboratory has remediated their finding, and ANAB has issued continuation of accreditation based on the results of the assessment activity. Do we have any questions for the lab? Seeing none, we'll move on. Nassau County Medical Examiner, Division of Forensic Toxicology. This is for informational purposes. No vote is required. The laboratory has notified ANAB and the commission that Dr. Joe Abella has been reappointed as their chief toxicologist on a part-time basis. And then also in March, A&EB conducted a surveillance assessment activity. There were no findings. A&EB has issued a continuation of accreditation based on the results of the assessment activity. Do we have any questions? We do have representatives available virtually. Swiftly moving along. Next up, New York City Office of Chief Medical Examiner, Forensic of Toxicology, Department of Forensic Toxicology, pardon me. This is also for informational purposes. No vote is required, and we do have a representative available virtually to speak if there are any questions. In April, A&EB conducted an assessment, a surveillance assessment activity. There were no findings, but there was one opportunity for an improvement suggested. The assessor felt that the laboratory would benefit from evaluating their process and required documentation associated with reviewing the effectiveness of corrective actions. It should be noted again, though, that this was a recommendation and it does not require specific action to be taken. A&EB has issued a continuation of accreditation based on the results of the assessment activity. Does anyone have any questions for the lab? Jessica does. If we could elevate Gail Cooper, who should be available virtually. All right, I think Gail is.
I can hear you now.
Okay, great. We can hear you too. Go ahead, Jessica.
Hi, good morning. Just a quick question. I didn't see in our materials any response from your lab about whether you're going to take up ANAB's suggestion about monitoring the effectiveness of corrective actions. Have you thought about it? Is that something you're going to be working on, or are you rejecting it, or do you know?
Yeah, so we already do what the lead assessor had suggested to us, that we record it in a more formal way so that it's something that we can more easily pull and show her. So we already evaluate our effectiveness. It's just a way of recording it, and that's what she wanted to suggest as an improvement.
So are you working on how you're recording it, or sorry, I'm just
how we record it on our documentation, how we document the effectiveness. So we routinely discuss it during our quality meetings, and she just wanted to make sure that it was more detailed, exactly what we had discussed, as opposed to saying effectiveness had been assessed.
Okay, thank you.
Thanks.
Any other questions? Okay, thank you, Gail.
Thanks.
Next up is the New York City Office of Chief Medical Examiner Forensic Anthropology Unit. This is for informational purposes and no vote is required. We have members of the lab available virtually if there are questions. The laboratory has submitted a request to A&EB for a scope extension, and they are awaiting a response from A&EB. So there's a pin in this. We will see it again in September. Does anyone have any questions for the lab?
I guess a question for the lab or for us, but if there's validation, I saw that it was an added technique instrument. If validation is required, this is what we'll see in September. Do I understand that right, or?
So this, I think, what I have notes is that it's for the identification of a person on bone material. I'm not sure if this would require validation or not. If we did, again, we're waiting for A&EB's response on this, so I don't know. For scope extension, though, they do have to go in and do a visit.
Mm-hmm.
So they would review all the documentation then.
Okay. And we'll get that documentation in September.
Correct. Or whenever they complete the scope extension. I don't want to say September in case they don't do the visit and do all those things. We will definitely have acknowledgement from them by the September meeting. But in terms of the rest of the process, that falls where it may. Does that make sense? Okay. Anyone else? All right, next up, we have the New York State Police Crime Laboratory. This is for informational purposes and no vote is required. We do have members from the lab available to speak in person. The laboratory has submitted a request to A&EB for a scope extension, and we are also awaiting a response from A&EB on that as well. And the laboratory has notified A&EB and the commission that former Director of Quality Assurance, Dave Polakowski, has retired and that Julia Becker will be his replacement. Congratulations to both of them. Do we have any questions for the lab? Alrighty then. Moving on, we have the Niagara County Sheriff's Office Forensic Laboratory. This also is for informational purposes and no vote is required. We do have a member of the lab available to speak virtually. There are a couple matters in this. The first one is the laboratory notified the commission that Christine Giffen was removed as the director of the laboratory effective March 22nd, and that the quality assurance manager, Kevin Condell, will be the interim laboratory director. And then the second matter of business is in February, A&EB conducted a surveillance assessment activity. We did speak about this in March. There were 10 findings and 1 opportunity for improvement was suggested. The improvement was the assessor felt that the laboratory would benefit from ensuring revisions of the quality manual were carried from one version to the next. It should be noted again that recommendations don't require any further action on behalf of the lab. We do have the findings. A&EB did accept 1 of the 7 challenges to their findings and removed the nonconformity relating to standard 7.11.3.e. When they were reviewing that during the process, the nonconformity was found to be more appropriate applied to standard 7.11.3.d and 7.10.3, and was therefore moved to those standards, and the findings were found then. The laboratory submitted their corrective action forms and objective evidence for all of their findings, which was approved by their assessor. A&EB has issued the continuation of accreditation based on the results of the assessment activity. Do we have questions for the laboratory? We can pull up the member from the lab virtually. There's Pat.
I have just one question. Not sure if are they oh, there's Kevin, sorry. So this one goes to, it's located on page looks like page 2 of the Niagara documents, and it has to do with the whole TR-AR, where if a TR isn't done, it'll at least get an AR. I'm going back to the previous commission meeting. We've in Niagara, we've changed that, correct? In at least the bio section where you're going to 100% TR-AR.
Yes, we're 100% technical review across all of our disciplines. That applied to toxicology only, Pat.
Okay, so this was tox. Sorry, I messed the 2 of these up. And I did understand the whole situation of where you can review 90% of the document, but not be qualified in 10%, so that doesn't get reviewed. So I guess, thank you for I'm wrong on the discipline, but in the tox discipline, this rolls into a second question. What happens with the case that gets a 50% TR? Is that included as a full TR? Or do you make sure that other individuals are available in the tox section who have the qualifications to review that subject matter?
Right. We wouldn't have had the capability at that time to have an additional tox person that would be qualified in those methods in particular. So it would be it's a series of methods. We would have 14 at the time. We had 15 methods, and our second individual was only qualified in 12 out of 15 of those methods. So the last two methods, which composed probably 5% of the casework, there wasn't a technical review performed on those. The work done on those methods in particular, there was an administrative review, but all of the remainder of the work that the second examiner was qualified in did receive a technical review. And it was the stance of ANAB that this would not count toward the 100%. So the only way to get to that stage would be to either not perform those tests, just only perform the tests where we had two individuals qualified and we could get a 100% tech review, or we would have to outsource that information. Since then, our second person has been qualified, signed off, competency tested, and authorized in all the methods in toxicology, so we no longer have that issue applicable.
Okay, that's good news. I think that was my only question, Kev. Thank you.
Thanks, Matt.
Any other questions?
I have one, unless someone else wants to go first. No?
Go ahead, Jessica.
Thanks. I had a question about the beast issue, the limbs issue. I understand that your challenge was upheld, but as a result of the challenge, even though the challenge to the specific provision in ISO was upheld, it then became a finding under two other provisions of ISO, like maintaining the integrity of the data. My question to you is this. I just want to make sure I understand this. Someone in the lab made just probably sounds like a routine error in copying a table in limbs, in the live limbs environment, whatever that means. So something was duplicated or something. So that would seem to be something that would not be infrequent or a huge deal and must happen. It happens to me all the time when I work on stuff. But what is worrisome to me was the response on how to deal with that. And correct me if I'm wrong, but I'll actually quote what ANAB said about it. So ANAB said, while human error only affected two columns in a table, a decision was made to delete all data going back to the last backup date and rebuild much of the electronic information for 140 cases. That's the part I don't understand. Okay, a mistake was made. Is there not the ability in BEAST or your LIMS system to cross out the error or make a note and then redo it rather than unplug the thing and erase data? I mean, that's the part that's scary, because then when you have to re-input it, there's a greater chance of error.
I can answer that question. Yeah, it's a little complicated, so you gotta just bear with me for a moment. And also, the word erase data is very loaded. What happened was that someone took a portion of the production environment, we call it. This is the active live part of LIMS, and copied it into the test environment, because there was a move made in order to get LIMS to do some more work for us, essentially, to get better statistics and so forth. So this was the agency name and the agent in particular who would be the submitting agent for the case, and that data got copied into the test environment, but it got copied incorrectly, so it populated twice in the BEAST. That was the only information that was impacted. Now, obviously, we can't have that duplicated in two different circumstances, so we worked at the time with our IT department to develop a plan for removing that out of the BEAST, and then repopulating it with basically rolling it back to where it was previously. So what we did is that we had that copied into a location, a safe location. All of the data was copied to a safe location, and then it was rolled back And then that was back checked against all of that previous data to ensure accuracy. And that was performed, that was successful. And the issue that ANAB had is that we didn't have anything in our SOP to prevent that particular situation from occurring. The reason the individual copied into that test environment is because we routinely, we tried to get in touch with Porter Lee several times, and Porter Lee was not responsive with us. So that individual made the determination to go ahead with that very technical process, and that's when the error occurred. So we've implemented, we sent a letter out. This is per our ANAB auditor. We've sent out letters to everybody, let them know, do not make this change in the beast without IT's assistance, and that's written into our SOP now, so it can't reoccur. And then also, we're very much a paper-based environment. So in our laboratory currently, this is not our future LIMS that we're attempting to purchase and get on board. In our current environment, LIMS is only used for the purposes of report writing and for chain of custody. But everything else is done on paper, and then that's scanned in and put into the LIMS. So we have a official copy, which is on paper. So anything that's done to the LIMS could be deleted and we'd still have a copy. But we just still have the original copy of every single thing, with the exception of if any active chain of custody or reporting issues were run. That's the environment we exist in right now. It's a hybrid environment. We're moving out of it. We're getting LabVantage. We've already paid them the first installment, so they're supposed to be coming in, and we'll validate that at that time and move fully forward into digital. But that's why the data has integrity. It's safe. Nothing happened to it.
I appreciate that information. I mean, one of the concerns is LIMS is discoverable under the law. LIMS data, even if you have another copy of it, it's still discoverable. And if there's been some alteration, even if you're saying, you copied it and moved it to somewhere else and then copied it back, that's still something that should probably be communicated to the district attorney's office, since it affects discovery that is mandated by law. So have you talked to the DA's office about that?
About this LIMS issue, we would have noted.
Among the others.
We've sent letters out to all of our customers that we have had out of service events, things of that nature. But I can't speak to. I don't have the knowledge to determine whether or not that was made at that time, because I arrived in October of 2023. Whether or not it was communicated at that time, I'm not certain.
Okay. I mean, there's still an opportunity to do it now, even though the nonconformity's been resolved. You can still notify the DA now and should.
Okay, that's fair.
Thank you.
Any other questions? All right, we'll move on then. Thank you, Kevin.
Thank you.
Moving on to the Onondaga County Medical Examiner's Office of Forensic Toxicology Lab. This is for informational purposes and no vote is required. We do have a member from the lab here to speak if there are any questions. In March, ANAB conducted a surveillance assessment activity. There were no findings. ANAB has issued a continuation of accreditation based on the results of the assessment activity. Do we have any questions for the lab? Congratulations. Suffolk County Crime Lab is up next. Again, for informational purposes, no vote is required. We do have a member of the lab available virtually if there are any questions. The laboratory submitted a request to ANAB to remove document examination from their scope. ANAB sent an updated scope, which was verified as accurate by the laboratory. Does anyone have any questions? All right, next up is the Westchester County Department of Labs and Research Division of Forensic Toxicology for informational purposes. No vote is required. Members available virtually if we have questions. In March, ANAB conducted a surveillance assessment activity. There were no findings. ANAB has issued a continuation of accreditation based on the results of the assessment activity. Does anyone have any questions? All right, last but not least for this portion of the agenda, we have the Yonkers Police Department Laboratory. For informational purposes, no vote is required. We do have folks virtually if there are questions. In May, ANAB conducted surveillance assessment activity. There were no findings. The laboratory is waiting on their final documents from ANAB. So that means we will see those final documents at our next meeting. Are there any questions for the laboratory? All right, congratulations to them as well. We will now go to old business. I will provide an update for the familial search program. Let me just get the data so I don't misspeak. So as of today, we have received, since our last meeting in March, we've received 2 new applications for familial search. One was a renewal and one is a new application. 1 application was withdrawn and 2 additional searches have been completed. So in total, we have 59 applications, 42 of which have been approved, 1 in progress, 13 rejected, and 3 withdrawn. Of those 42, we have 8 in the search queue that are in process, 34 searches completed, and 1 conviction based on 1 of those searches. Do we have any questions about the familial search data? Okay. I just want to also make mention that the partial match and familial search policies were last reviewed, updated, and approved back in 2020. And we did say that we would do periodic reviews of these policies, so to ensure that our mission efforts of continuous improvement are being met. There will be a review of the partial match and familial search policies. What we will do is we will disseminate the policies to the members. We are also doing the same with the DNA subcommittee, and we would like you to take a look at those and reach out to our office if you have any recommendations or suggestions for edits to those policies, and then we can do an update in the September meeting.
Is there a general sense, I mean, the system we put in place was voluminous in its multiple steps. The numbers are small.
Yes.
Is there a sense from the office, who puts in much of the effort, that we should be taking a mind to consider some streamlining? Or is the office satisfied that the system works?
In what sense of streamlining, I guess I would ask?
Some of the levels of training, the in-service training, the personal training of all the different aspects of before you can proceed. I'm not saying that I have a position. I'm just, those who have been most involved of looking at the documents, dealing with the requests, and I'm sure repeated communications in this process, whether there's a sense that we should be, looking to make this a little smoother, a little less. Do you think it would increase numbers? Do you think it would increase effectiveness? Or are we at a good low, it seems like a low utilization of a system that was advocated for very strong, that it was going to be the panacea of unsolved cases, and that it was going to speed up the process, and with 1 conviction in 4 years, it's a low yield.
But to be fair, the program was on pause for quite some time.
Yes,
with litigation.
Yes, it was.
And I do want to say that from the administrative side of things, in terms of the application and the process that we go through, it is very rigorous, right? But there's a reason why. And I think we evaluated that early on when developing the program for protection purposes. So I will say that I think that the crimes that are enumerated are still valid, and those are the ones that we should be using the resources on. Otherwise, I think that we would really need to evaluate and determine it's a significant amount of resources to use for this program, right? So I don't want to speak on behalf of the lab side of things, but I will say that, there is a balance to be struck with this, right? I also, onto the tail end of things, will say from the administrative side that, I consider there to be great value in the training that we require, and for several reasons. First of all, informational purposes alone. I would hate to send someone a letter and not give them guidance like we do, particularly regarding the confidentiality aspect of it. It's imperative, right? For the protection. The individuals' names we are giving are not the ones that are the one that committed the crime. And I don't know how many times I can say that during a training, but still a part of me rests my head on my pillow and gets a little scared. I'm not gonna lie, because you're bestowing on them the importance of this, of not going to someone's door and making accusations that are just not correct, right? I just would hate for that to happen in the program. So the training aspect of things, I do think that is still a requirement, necessary, and conducive to the program. I do know that we are looking at giving more suggestions on the tail end of the training for resources available to help them further with the investigative lead if they are given a candidate name, in order to help guide them, right?
I think it's also important to remember that the match and conviction is not the only measure of success. It's also removing individuals from consideration, which has been helpful as well.
I mean, I think the program is a model, and I think it has done what I would have preferred. It's a very cautious, well applied. We limited the crimes and we required the training, so that before we run headlong into using these kinds of matches, there's a reason to do it. And there's an expectation that it will be used expeditiously but carefully. But I just thought getting an impression from those who really put the time and effort into it, and the legal department that had to deal with the lawsuit all the way to the Court of Appeals, is not trivial.
Judge, I saw you had raised your hand, so I want to make sure that we acknowledge.
Yes, I was just going to say that I believe that one of the reasons that the Court of Appeals affirmed our ability to institute the familial search is that we had a very rigorous process before we allowed it to be used. And I would be very concerned about us if we ever attempted to quote unquote streamline that we would, stepping over that rigorous process that was, part of the approval of the Court of Appeals.
I will say, there are obviously other technologies available that may have kind of stepped in place of familial search, but we continue to do the diligent work that we do and the way that we do it. And I continue.
You're referring to the genealogy.
I may or may not be referring to a can of worms that I don't want to open right now. Yes, but I'm just saying that, there are definitely other alternatives that are out there. I also would like to take note that we do our very best to maintain contact with the agencies at the every 6-month mark that they have received a result, so that we can continue. How is the investigation going? How is this benefiting your investigation, and getting data from them in that aspect? So,
thanks for the update.
You're welcome.
A lot of information.
I will turn this now over to Colleen.
Commissioner, with your permission, I'll step in now. We have 2 additional old business matters. The first relates to an emailed letter received by members of the commission on 3/18/24, in addition to a follow-up letter that was sent this week. And related to that is the request by the Onondaga County to speak to the commission. If the commissioners would like to discuss or decide whether they would like to approve that request? You already voted on that. That's right. So we can address that now or any further issues with that matter. Would we like to call in Onondaga County? Okay.
Yes.
They're here.
They are, right here.
Perfect. And we'll give you the same reminder. If you could just speak into the TV, we will not think that you're being inconsiderate at all. And if you could, please identify yourself to the commission.
My name is Justine Cresso. I am the firearms section supervisor at the Onondaga County Center for Forensic Sciences.
My name is Renee Ho. I am the Director of Laboratories at the Onondaga County Center for Forensic Sciences.
Thank you for being here today. Are there questions? Or would you like to speak? Tell us why you come today.
There was a discussion related to analysis that our laboratory performed, which, well, originally originated in 2016 and 2017, that our laboratory had performed this analysis. And in 2019, we were made aware that the New York State Police had reanalyzed that evidence, and we had been contacted by the defense attorney in that case to discuss a discrepancy of results. In that case, it was an identification that was made by the New York State Police between one of the cases that we had analyzed, which was a homicide, to a test fire. And our laboratory had issued an inconclusive result in that analysis, and the New York State Police had identified it. That kind of kicked off a series of events that involved our laboratory reanalyzing the evidence, submitting the evidence to a third analyst in our laboratory blindly to do their own analysis, and subsequently resulted in a mediation session between the New York State Police, two individuals from the New York State Police, two individuals from our laboratory, as well as a mediator who was from an external laboratory and was a qualified firearms examiner. The results of that was the New York State Police stood by their identification. Our laboratory felt that our inconclusive was the appropriate result in that, and then identification was not the appropriate result. Both laboratories stuck to their analysis. As you guys heard last time, that resulted in an IG investigation and subsequently complaints made to the commission. There was a lot of confusion, it seemed like, at the last commission meeting as to the exact chain of events that occurred. So I wanted to make myself available to answer questions, to kind of correct some assumptions or things that were said, as well as hopefully come to like some kind of resolution on this topic. I was the original verifier involved in this case. I was involved in the reanalysis. I was involved in the mediation session, and then the corrective action or quality and actions that our laboratory took. So I feel like I was involved sort of in the process from start to finish. So I would like to make myself available to answer questions.
Thank you. Other questions?
So the two labs stuck to their discrepant results, right?
Yes, that is correct. It was our laboratory's opinion that this was not a threshold issue. This was a difference of opinion in which there was not support for an identification.
So we have two labs having looked at the same evidence, coming to a different conclusion, right?
That's correct.
It was a murder case.
Yes, it was.
The impact of the discrepancy on the case?
Ultimately, the prosecuting attorney, this was an outside agency to be clear, it was not Onondaga County, decided not to use any of the firearms evidence in the trial. So no one testified to it.
Yeah, so the result of the discrepancy was that the evidence was not used.
In the trial. correct.
Indirectly, yeah, okay.
I don't know if you have this much knowledge about that case, but my understanding is that it was a Utica case, correct?
Yes, that's correct.
And they had received an anonymous tip that the gun used to murder this victim in an as yet unsolved homicide case could be found at 123 Main Street under the stairs. Something to that effect?
I don't recall the scenario in which this particular firearm was submitted to us and what the circumstances were. There were several guns that Utica Police Department had submitted to our laboratory with a request to compare to this homicide, and there was also a separate case in which we had conducted a comparison and identified those two crime scenes to one another.
So Utica gets the gun, and my understanding is for time purposes, because you could do a more rapid turnaround than the state police, they submitted it to Onondaga.
Yeah, I don't want to go into or hypothesize what the motivations for Utica using us at the time were. We were working a significant portion of their cases at that time, yes.
So you look at the test, you look at the subject gun, you test fire some projectiles, and you compare it to the projectile recovered from the victim.
Yes, that's correct. Originally, there were 2 bullets in the shots with injuries that were recovered and submitted to us. We identified those 2 bullets to each other. The homicide had 2 autopsy bullets and 1 crime scene bullet, and we originally identified those to each other, as well as identified the 2 crime scenes to one another. And then the gun was submitted later and compared.
And you have 3 choices. You can say it's not the gun, it is the gun, or inconclusive.
Correct.
And you selected inconclusive.
Yes, we did.
And was your work verified by anybody at Onondaga?
So the original analyst was not myself. I was the verifier in the case.
So reverse that, you verified the work of someone else.
Correct.
And then submitted a report to Utica.
Yes, we did.
And when this evidence was, I don't want to say was it repackaged by Onondaga?
No, I believe it was in its original packaging as it was submitted to us.
Was it clear by the packaging and returning to Utica that the gun had been examined by Onondaga?
Yeah, so for firearms, there would be a green Center for Forensic Sciences safety check sticker. That's a policy for us for guns to be safety checked. In addition, we have L case numbers for our laboratory. So the box would have contained or had a yellow lab number on it. Additionally, the firearm was marked by the firearms examiner at our laboratory. And then the evidence from the crime scenes, the autopsy bullets would have been labeled with an M series number signifying they were recovered by the medical examiner's office. The evidence all had yellow labels as well from our laboratory. Again, that's an L series number. And in addition to that, they would have been marked by our firearms examiner who analyzed the case.
And then at some later point, the next contact or the next involvement that Onondaga has with this case is a call from a defense lawyer from Utica.
Yes, that's correct. He originally contacted us in April of 2019.
And his inquiry is did you guys examine this gun?
Correct. His inquiry was not understanding how there could be 2 separate laboratory reports on the same analysis from 2 separate laboratories, and also noting that there was a discrepancy in the results. So he was hoping to meet with us to try to clear that up. Of course, that was at that time the first time we had heard anything of the situation.
All right, you anticipated my next question. So this is, you only became aware through the defense lawyer that another agency had examined the same gun?
Yes, that's correct.
Okay, so now you make efforts to verify the veracity of this assertion by the defense lawyer?
Yes, so the first thing that we did was attempt to verify that we had in fact, or the gun in question had been analyzed by us previously. This involved communication between our laboratory as well as the New York State Police. When we determined that it did appear that the same firearm and evidence had been reanalyzed by another laboratory, we requested a recall of all evidence in the case, including the original shots with fired complaint, the homicide in question, as well as the firearm. We also requested the test fires that the New York State Police had generated on the firearm.
You make that request to the New York State Police Crime Lab?
Yes, we facilitated through the New York State Police and Utica Police Department to have all of those items resubmitted to us.
Was that request eventually complied with?
Yes, I don't recall any kind of hesitation with that request to have the evidence resubmitted.
And you then scheduled what you refer to as a mediation session?
No, so there was a series of events between us receiving the evidence and the mediation session. The first step was the original firearms examiner involved in the case and myself as a verifier, analyzing the evidence. So what we first did was compare the crime scene bullets to our test fires that we had regenerated. Our laboratory felt there was not support for an identification in that initial reanalysis. So the next step we did was try and determine if potentially there were some variations of markings between the test fires we produced as well as the test fires that the New York State Police produced. Certainly that is possible that there can be a lack of reproducibility between brands. We had generated several test fires and we did not have a problem identifying the knowns to each other. So that didn't seem likely, but we also wanted to compare what the New York State Police had used. So we did test fire to test fire comparison between our laboratory's test fires as well as the New York State Police's. We found that there was sufficient reproducibility and we were able to identify those to each other. From there, we then used the New York State Police test fires and we compared them to the autopsy bullets from the original homicide. After that analysis was completed, we then submitted that to a third examiner in our laboratory blindly. So she worked up the same type of analysis without any of the notes or context as to what was going on. She also came to the same conclusion that it was an inconclusive. We noted that there was some disagreement in the groove impressions and subclass characteristics. And after she had completed her additional analysis, we were still trying to potentially explain how one laboratory could identify the bullets, and we not find any support for that. So we then cast the barrel of the firearm. The purpose of doing that was to ensure that the subclass characteristics that we were observing on the test fires produced by the firearm were in fact for the manufacturing process versus use and abuse that could have occurred after the homicide and the initial recovery. The cast of the barrel did not indicate that there was any damage or any kind of abuse to the firearm that would have explained that. And those marks in the subclass characteristics that we were seeing that were what I will say is in disagreement to the crime scene bullets was evident on the cast and appeared to be manufacturing related.
Do you know, let me go back. So you physically had possession of the gun in the Onondaga lab for this re-examination?
Yes, that's correct. We asked for the firearm to be recalled to our laboratory.
Okay. Do you know how it is that a murder weapon, while a case is pending and the appeal is probably pending, made its way to Onondaga simply by your request?
At this point, I believe we were approximately a month away from the trial because this reanalysis occurred shortly after the defense attorney had contacted us. So as soon as the defense attorney had contacted us and we realized there was a potentially a serious situation that was occurring, is when we set the chain of events in motion to have the evidence all recalled to us. I believe the trial was towards the end of May, and the evidence all was received to our laboratory, I believe between April 26th and, April 26th is when we got the firearm and the crime scene bullets back to us. And I believe it was on May 1st that the test fires from the New York State Police arrived.
So nobody from Onondaga was subpoenaed for the trial of this individual, his name escapes me, who was convicted of murder, and this gun was not used.
The Onondaga County District Attorney's Office did subpoena the original firearms examiner, just chose not to have him testify.
Okay. So now there's a mediation session, and when does that occur?
Yeah, so after our laboratory did our reanalysis, the evidence was mailed back to the New York State Police. I can't speak to anything that occurred at the New York State Police, obviously. We were just informed at some time shortly thereafter that they felt that their identification was still valid and they were going to keep their conclusion intact. So that is when we decided to initiate the mediation session.
And is, for those of us unfamiliar with that, what is that mediation session? Is that something mandated by ANAB or ASCLD Labs, or is it just something you do on your own?
This is a slightly unique situation since typically like conflict resolution policies, obviously, as you guys know, revolve more around how to resolve conflict within your own laboratory. So the purpose of the mediation session was because our laboratory conducted our reanalysis. We felt very strongly that an identification was not an appropriate conclusion. And the New York State Police felt very strongly that their identification was the appropriate conclusion, that we wanted to see if we can kind of come to the table and show the analysis that both laboratories conducted, as well as try to demonstrate that. So it was myself and the original examiner from our laboratory that were present, the original analyst from the New York State Police, as well as the technical lead of the New York State Police for the firearms section, and then the third party who was a qualified firearms examiner and former lab director.
And the, I guess we don't want to name names, but can we at least identify the mediator?
I would like to defer to that as an attempt not to, I'm not sure that individual is aware of any of this. So I would be happy to provide the individual's name in private for now. And certainly if you guys decide in the future to talk to him, that would, you know, I'm sure
Who selects him?
The my current the laboratory director at the time and the New York State Police lab director discussed that. I am not sure exactly how that conversation unfolded. That would be a conversation for them. The individual in question was still active in the field of firearms examination, and since they, you know, were a previous lab director and had so many decades of experience, they were suggested and accepted by all parties.
And not knowing who this person is, do they have any connection to the state? I mean, would they favor one side or the other, or they, as far as you know, they're objectively neutral individual?
Well, I would say that everyone was in agreement for this individual to lead the mediation session. The vast majority of this person's experience was in another laboratory. After they retired from that laboratory, there was a time that they worked in our laboratory. That by the time they had, or this had unfolded, they had not been at our laboratory, I believe, for approximately 7 years, and they were back working in their former capacity at the other laboratory.
Can you give us a Reader's Digest version of the mediation session? Does one side present their conclusions, and is there a question and answer? How does it work?
The way the mediator had chosen to structure it was a comparison microscope was brought into the laboratory's conference room. All the evidence was present during the mediation session, and essentially both sides had the opportunity to put the evidence up on the comparison microscope, try and demonstrate why they felt they had support for their conclusion, as well as try to collaborate to determine where both of us were coming from.
And does the mediator at the end of this offer his opinion?
He did not offer his opinion in the room. He simply acted as a neutral party, kind of guiding the discussion, asking everyone to talk about their notes, their photographs, try and demonstrate what we were observing out of the microscope. And then at the end of the meeting, we just simply ended, and then he had conversations. Again, all I can speak to is the conversations that were had in our laboratory regarding this incident with the mediator. And obviously I can't speak to conversations that occurred with the New York State Police.
So at the end of the mediation session, the original examiner for the state police, plus his or her tech leader, stood by the opinion that that gun was the murder weapon.
To be clear, the technical lead of the New York State Police was in no way involved in the analysis or verification of this. That individual did not ever, to my knowledge at least at the time of the mediation session, had not actually examined the evidence in question. The original analyst, at least when the mediation session wrapped up, and obviously we found out later the conclusion wasn't changed, felt that there was support that existed for their identification at the time.
Okay, so of the leaving out the third examiner from Onondaga, so of the four analysts, two from the New York State Police, two from Onondaga, and one mediator, what was the final conclusion amongst the five? Was it 3-2, 2-2, one undecided? I mean, who said it was fired from that gun? Who said it wasn't fired from that gun?
So the second individual from the New York State Police remained neutral in the sense that they did not actually have the opportunity, at least up to that point. Again, I don't know what occurred afterwards or have direct knowledge of what occurred afterwards. Because they did not analyze that evidence, they appeared to stay neutral on the subject. The communications between our laboratory and the mediator after the session was concluded indicated that they felt our support for our conclusion was strong, and they understood where we were coming from with our conclusions, and they didn't find any major concerns during that session.
And did that conclude your involvement or Onondaga's involvement with the case?
As far as
prior to the commission's meeting from several months ago?
Our laboratory did complete some quality steps from that point forward. Obviously, we felt we did not find any nonconformities, so we completed our documentation as far as that occurred. And then at the end of the year, we issued a performance disclosure on this as well. Due to the seriousness of the issue, we felt like it needed to be in that document for transparency purposes.
Okay.
And then at that point, we concluded any action until.
All right, and just for my fellow commissioners, I've spoken to the former Onondaga County District Attorney, who informs me that an individual was convicted of this murder and that this gun, in his judgment and the judgment of the trial prosecutor, had nothing to do with the case. So, thank you. I have no more questions at this time.
I think Dr. Buffalino has a question on. Can you hear us?
Pat, unmute.
You're up.
Sorry about that. I'm having a little hearing issues, so I've got to ask a question first. Was the referee or the mediator, third party, I'm hearing that they were a former employee of Onondaga, or they were not?
They were for a brief time. They were a laboratory director and a firearms examiner in another laboratory. And for a brief time was employed by the Onondaga County Center for Forensic Sciences, and then had not been an employee of our laboratory for approximately 7 years.
Okay. It was, and again, I think I'm now talking to other commission members here at this point. Might be valid at this point now, because we're hearing from Onondaga. Hopefully at some point we can hear from the state police examiners, but if I'm recommending a referee lab of an individual who has no connection to New York State, no connection to the laboratories, doesn't even know anything about this particular case. But I'm not quite sure whether, we can push for it, whether anyone else thinks it's of value. It's just kind of tough to hear that, all right, well, they said inconclusive, we said conclusive, they stuck by their guns. I'm certainly not a firearm examiner, so I'm not going to ask for the case file, and especially digital images, because we all know that PDFs don't do any justice, or maybe even give out the original evidence, but I'm in favor of a referee lab if anyone else is.
Are there additional questions?
Yes, this is Jessica. I do second Pat's suggestion, but I do have a couple of questions as well. Could you explain what your criteria are? Well, first, let me make sure I got this right. I think DA Fitzpatrick asked, you have 3 categories of conclusions, I know some labs have a more, have like a 5-point scale, but you have a 3-point where it's exclusion, inclusion, inconclusive. Is that right?
Yes, that's correct. New York State reporting guidelines for labs in the state had years ago decided to stick to the 3-point scale for conclusions. As you said, would be an identification. It's straight inconclusive, just simply a sufficient agreement or disagreement not observed, and an elimination.
And what are the criteria for an exclusion? And I think you may have said it for inconclusive, but could you explain what the criteria are for each conclusion?
So there's 2 sort of categories, I guess you could say, of an elimination. The first would be a class elimination, which means the characteristics that are determined prior to the manufacturing process. So for a bullet, an example of this would be the number of landing groove impressions or the twist direction. For one manufacturer, those might be 5 landing groove impressions with a right twist, and another manufacturer might have 6 landing groove impressions with a left twist. So that would be an example of a class elimination. A individual elimination means that you're seeing the same class characteristics, but you have sufficient sufficient disagreement of the individual characteristics to eliminate those 2 items of evidence from being fired from the same gun or the test fires. The criteria typically that you would like to see for an individual elimination would be showing reproducibility amongst both groups. You would want to see in the individual characteristics significant differences within those marks. For instance, one firearm in the land impressions could have heavy continuous marks in the land impressions that are reproducing, and the other firearm may have very fine and irregularly spaced marks within the land impression. So those are some of the things that could support an elimination on individual characteristics.
And what about for the inconclusive category?
So the inconclusive, again, in the notes, you can kind of expand on your support for an inconclusive. So for our laboratory, we documented that there were some differences between some of the marks in the groove impression or the subclass characteristics between the homicide and shots with injury cases, as well as the test fires. Our laboratory, however, did note some random agreement in the land impressions. So we felt that an inconclusive was an appropriate response on the scales of class characteristics being the same.
Is there a sufficient, or is there like a required number of differences that has to be reached before it goes from inconclusive to an elimination, or is it case dependent, or?
No, there's not a requirement for specific criteria for an elimination. Again, typically what you want to see to account. So eliminations on individual characteristics are always proceeded cautiously in the sense that there are a lot of factors that can cause a firearm to have significant reproducibility and variation in the marks, even though they were fired from the same firearm. Ammunition type, an example that's great with bullets is lead bullets versus copper jacketed. Oftentimes, bullets fired from the same firearm can reproduce quite significant or insignificantly, and make it so an identification between the test fires is not possible. So typically, you would like to see a variation of ammunition types that are reproducing consistently across brands with your crime scene evidence, as well as reproducibility amongst brands with the test fires before you would consider an elimination.
Thank you.
Are there any other questions?
One quick one. So the verifier for the state police for that case wasn't at the mediation meeting?
They were not.
Do any other commissioners have questions at this time?
This is totally a curiosity question. So this gun comes from Utica, gets sent to Onondaga for lab analysis, gets sent back to Utica. I mean, that's what happens to evidence. It returns to the investigating entity, right? Then somehow gets sent by Utica to the state. And then Onondaga finds out that it's been tested by a second lab. It's now back at Utica, right? The gun's in Utica again. Now it comes from Utica to Onondaga, and it's now back in Utica?
The firearm, I believe, stayed at our laboratory until the end of 2019. And yes, Utica Police Department retrieved the firearm and then brought it back to Utica.
Utica.
Yep.
I
don't know where it is currently, at least I know our records indicate that.
I have a question also. In amongst the discussions, was there ever a conversation with Utica why they sent it to the state police after they had your report?
I believe I will say that Utica was aware that our laboratory had analyzed the gun and issued an inconclusive result when they submitted it to the New York State Police.
Right.
Specific motivations beyond that, yes, and we had numerous conversations. We had at least a couple conversations with them about the results of our analysis originally. So they were aware of that. They had our report.
Just to clarify, when you say them.
Utica Police, yes, sorry, Utica. Yes, Utica Police Department was aware. As far as the specific reasons as why they chose to do that, being aware that we had already analyzed that evidence, that would be best directed to them.
Okay, and James.
That was the same
That was
question
it,
as how it
okay.
was shuttled back.
I have a question. You mentioned earlier that the evidence after you first examined it would have been labeled with a variety of different tags. When you re-examined it later, what markings were on there? What tags were on there? Were any of those original evidence?
All the original evidence labels from Utica Police Department to our laboratory, to the medical examiner's office, to the marks on the gun, to the marks on the evidence were all present when we did our reanalysis. And then in addition to that, obviously at that point, there was also additional labels from the New York State Police.
Okay.
Any additional questions? The state police is here as well, if there are questions for them.
In the field of ballistics, knowing nothing about it, is it uncommon for two labs to come to different conclusions? I mean, we hear that these, bullets are bullets and guns are guns and things change and, is this an uncommon event or is this, it happens?
Typically, you can have differences in opinion when it comes to inconclusives in a source conclusion. However, both parties need to come to an agreement that there is support for the source conclusion. So it is not common for two laboratories to disagree with an inconclusive in a source conclusion. But one laboratory not be able to feel that the support was demonstrated for the source conclusion.
Okay.
And I've been prosecuting murder cases for 40 years. I've never seen a identification refuted in court by vigorous, competent defense counsel who had access to other labs.
But we're looking at the other end of the not match. Or was it a match in the police lab? The state police?
Yes.
Yes.
Oh, okay, I'm sorry. All right. No.
What happens in proficiency tests? Because when we get the results from the vendor after the fact, what is the, is there something that may mirror what happened here where, where a significant amount of the test takers are varying from what the main percentage arrive at as a conclusion?
There are certainly instances, especially when you have poor quality marks or lack of reproducibility amongst the samples that you're examining, where you might have a large variation in answers, and certainly you can have false inclusions or exclusions in those circumstances. This particular circumstance, reproducibility was established amongst two separate crime scenes, and reproducibility was established for the test fires amongst certain brands. So this is typically a situation where you would not expect a large variation in conclusions. But obviously, the situation we're talking about is not a PT type scenario.
PT materials that you get are actual ballistics or are they photographs?
Yes, for proficiency tests, we are actually examining fired ammunition components.
Okay. We haven't had an in-depth discussion about ballistics, I don't believe, in the history of the commission.
Yes, we did. We actually had a guy come here once, testified about error rate.
Yeah, but it's a long time
Yeah, it was you and I were the only ones, Chair.
I mean, I've been here for 24 years, so.
The defense lawyers thought it was all
Time
voodoo,
ago.
and the prosecutors thought it was the gospel according to St. Mark.
All right, so if there are any questions, any further questions? I don't think, and the representatives of State Police Lab are here if there are questions for them, after hearing this additional information.
I think we have a follow-up question with the state police based on what we were just asked Onondaga.
And thank you very much.
Thank you.
And why don't we, I think we should just pull those chairs like right up to the TV. Does that make sense?
Luckily, you're
Right? It appears that people are still struggling, right?
Yeah.
Yeah, let's just put them right.
Good
let's
idea.
just sit right
Yeah,
there.
right there.
Oh, perfect, that's not awkward at all.
Things have been awkward before, right?
You guys want to sit across from each other, next to each other?
No,
Oh, boy.
we know.
Boy, this is different.
I just wanna make sure.
Hey, right in there.
I wanted to get a really good look at you, Pat. Does my nose look big from this dimension?
It looks good, Ray.
Okay.
So Onondaga was asked, and I don't even know whether I'm stating this right or not. How did it come about that there was the knowledge of a discrepancy between the Onondaga results and the state police results? Or were you all aware, was the state police aware that there was a discrepancy with the state police results and the Onondaga results?
Yeah, so how this came about was, it was a mistake on our part. So we have distinct policy that says you do not re-examine other folks' cases. There was markings, as indicated, that should have been caught. And as a result, we did have a nonconformity. We wrote a letter that was provided to the commission. So we did have a nonconformity. It should have been caught. We put steps into place to make sure that didn't occur. So we were aware, and as everything was indicated, yes, there was a difference in terms of they had an inconclusive, we had an inclusion. But that was fully disclosed. It wasn't a letter, and we have made corrections to make sure that they've occurred. We should have seen the markings. And typically, evidence does go through a number of hands. So you do get a variety of markings as somebody is seized it at the scene, may go to another person. So you do see a variety of initials, and all of that's normal. We just did not see and should have seen Onondaga's markings, and it should not have been re-examined.
So there was no reach out from Utica saying, hey, this other lab gave us this result, and could you confirm it for us or refute it for us?
That's correct. And once I realized that we had inadvertently retested Onondaga's evidence, I reached out to the detective and said, did you know that this evidence had been previously submitted to this other lab? And he said, yes. And I asked him, why did you do that? He said, I wanted a better answer. I mean, that's the truth. But I want to say it was a brand new detective in the crime scene unit, and I just don't think he knew better. So that's what happened.
That was a detective, you said?
He was a investigator, yes.
Did anybody from the district attorney's office reach out?
I'm not sure what you're asking. I'm sorry. Can you?
There'd already been an arrest made.
I did not know that at the time. I learned about the inadvertent retest when Dr. Corrado, then the CFS lab director, contacted Director Wickenheiser and reported what the defense attorney had reported to her. So.
Is the tech leader that attended the mediation session still in the employ of the state police?
No, she's not.
Not the original examiner.
I understand what you're saying, that the technical coordinator has left state police.
Has that tech leader that attended the mediation session opined to anyone in authority at the state police lab as to his or her conclusions as to who was right and who was wrong?
Well, I will be transparent. I have no reason, we have nothing to hide here. When these individuals came back from the meeting, it was on a Friday, I believe. I spoke to them the next business day. The original examiner told me that she was nervous, and I believe, this is 5 years ago, so the tech coordinator thought that the Onondaga examiner made a better case for his conclusions. And she offered no official.
What about the original verifier?
5 years ago, that individual was not available to attend that meeting.
Is that individual still in the employ of the state police?
He had several contracts with us. His last contract expired on March 31st, and we have a bigger section now, so we didn't need him, so he's no longer in our employ.
He's no longer employed there.
That's correct.
Has he reconsidered his original verification?
So if I could, it was actually my suggestion to, I thought possibly, I'm not a firearms examiner, I have a lot of years of experience over sections with comparative disciplines. I've been the department head for 4 disciplines, 3 of those are comparative. I've reviewed over 10,000 firearms cases. I thought that perhaps there might be an issue with difference in the markings of the test fires. I talked to people at the Onondaga lab. We made arrangements to switch test fires. So using their test fires, we repeated at least some of the examinations with the original analyst and original verifier, and we stuck to their identification.
So, okay, so.
And additional reports were issued.
So the vote is Onondaga, inconclusive, mediator, inconclusive, tech leader, New York State Police, inconclusive.
I'm not sure I can say that accurately. She did not examine the evidence. She just gave me her perception of the, she did not.
I think you said that Onondaga made a better case.
That, I'm being transparent. You asked me, we're here, and I'm telling you the truth.
The 2 individuals who feel that it was a gun are no longer employed by the state police. Obviously, you had done a lot of casework for the state police.
Correct.
And I was curious, why would, if anybody actually thought it was the actual murder weapon, why would anybody release that a month before trial to another agency? If somebody legitimately thought that was the murder weapon.
Are you asking about what Utica PD did, or what are you asking? I'm not clear, I'm sorry.
Oh, it came, so it didn't come from the state police, it came from Utica?
What's that?
Are you talking about the resubmission?
Yeah, the resubmission.
Well, the resubmission,
This
when you
Cristo
consider,
was talking about, a month before trial?
That came from Utica PD.
That came from Utica PD,
Yes.
okay, fair enough, thank you.
I do have one question. If the tech lead came back and gave you the impression of her take on the meeting, was there any consideration to have it retested in your lab?
There were discussions, we could not, I felt we could not have it retested in our lab because you can't unsee what you've seen. And there was no one that didn't know about this. We didn't have a very large section at the time.
Gotcha.
We had discussions about having it retested, and then we came up with the idea of the blind PT.
Gotcha. Because everybody already was cognitive biased, right? You already know.
exactly. So just to build on that. So once you already know that somebody reached a conclusion, if you already know that a colleague has reached a certain conclusion, you can't unknow it. So the idea that if you have a connection, I already know what the answer is, you really need to have it done by an independent someone. Now, the part of the challenge here is there's already a ground, like you don't know the ground truth of what the actual sample is. You really don't know. So to actually do something appropriately, if you're going to retest somebody, you need to have a ground truth sample where you know what the right answer is. And hence why we preferred to go along that route.
Okay.
And that might be why Pat's suggestion is a good one.
But so if the evidence is marked, how do you reanalyze that without knowing? How do you remove that cognitive bias?
Well, you look at the original bullets that were the instrumentalities of death, and then with the test firing. those.
Those aren't marked? I'm sorry, I got the impression those were marked.
Well,
I can't, they typically are, but I can't speak
Yeah,
to this case.
okay.
because I don't know.
Okay, so I got the impression that you would know they were previously analyzed.
I'm not sure it's necessary at this point. I like Pat's suggestion when I heard it, but now that I hear that the New York State Police own tech lead says this is inconclusive, I'm not sure we need to do that.
I'm sorry, sir, I don't mean to argue with you. She said that the Onondaga examiner seemed to make another better case. However, she also opined that my examiner was nervous. Being put into that situation in, home field advantage, I'm not saying anything was unfair. I know this individual, she got very nervous. She all, this, tech leader, tech coordinator told me was that she thought this person was nervous and that the other person made a better case. She's not opining that it's
I don't know who this person is.
right.
She was nervous, You're with professional colleagues, you're verifying the information that you gave, that she's nervous. I don't show it, but I get nervous during trials too, but I still kick ass.
So, if I might, just sort of weigh in on, because the former director of Onondaga and I had conversations on what to do next. And this is a rare situation, and just bizarrely, you have this unique one-off, and it's an opportunity, I'll call it professional development. The fact that you have people who reached differing conclusions on it, why don't you sit down, show each other what you saw, and see if, in the very least, you can come away saying, I see what you saw, I see what you saw, and maybe somebody changes their mind, which is fine. On the other hand, not shockingly, they come to the same conclusions. It was an opportunity so that we can have a look at it in the spirit of continuous improvement. You don't have many situations like this, so to have a look at what each other was showing, have sort of somebody independently to moderate or to mediate, and it's appropriate that individual does not render a conclusion. They're there just to assist. So you show us what you saw, you show us what you saw, and furthering what Brad is saying, the fact that you have somebody who's nervous and jumped doesn't make their best case. Somebody who is at their home lab makes a better case. That's what we're talking about. It's not she agreed with one side or the other. She's saying that she didn't make as good a case as she could.
We had this conversation 3 months ago. What's happening is you're feeding into a narrative that this is not an exact scientific discipline. You may not realize you're doing that, but trust me that you are. I don't believe that. I believe it is a scientific discipline that's worthy of consideration by a jury. I believe efforts to have an examiner say that may be the gun that was used are nefarious and are detrimental to the administration of justice. I don't care if she was nervous or not. It's either that bullet either came from that gun or it didn't. So I suggest that we have it, we follow Pat's suggestion. We have it reviewed by somebody completely independent. And if it turns out that there's an additional opinion that the analyst was wrong, her casework has to be reviewed. And I say that because there's a significant difference between two people saying inconclusive and one person saying that's a match and somebody else saying it's inconclusive. Those consequences are catastrophic.
So first of all, let me totally agree with you. Firearms is a valid scientific discipline. That said, I also recognize, because I do have a comparative science, albeit not firearms background. And so I recognize that, and I'll use latent fingerprints, of which I'm not an expert either, just because it's a good illustration. You can know that a fingerprint originated from an individual. You can then have a smudged print that, even though you know it came from that individual, there's not sufficient information there to make that conclusion. I also recognize that you have different examiners working with different microscopes. Even though they're similarly trained in a scientific discipline, they can reasonably reach different conclusions. And by different, one isn't saying elimination, one is saying inclusion. One is saying there's not enough there for me to reliably reach a conclusion, and one says, I think I can. Okay. We also related at the last meeting that we had greater insight, where we did have a situation where, and this was fully before the commission, you're aware of it, where we had sent out to a truly independent third-party lab 51 different cases, of which 9 of them came back with this similar disagreement. 9 out of 51. That's a significant percentage where one reached inconclusive and the other reached inclusion. So we know that that occurs. And also, as alluded to one of the commission members, there was a recent proficiency test in firearms where quite a number of people reached differing conclusions of inconclusive versus elimination, if I'm correct on that. So even though this is a very valuable science and we 100% agree on that, this is a reasonably common occurrence where people who are both experts in the field can come to difference of conclusion based on their judgment, their training,
I appreciate the incongruity of that. You're saying it's a scientific discipline, but people can disagree. You can't have it both ways.
Between
No,
inconclusive.
that's not true. A scientific discipline has an error rate. Every scientific discipline has an error rate.
But when the difference in is, this analyst said that bullet came from that gun.
It is below or
If
above
somehow they were able
the
to
cutoff value.
if somehow someone was able to have tied that gun to a completely innocent individual, he or she would now be sitting in state prison.
The results can be catastrophic, but the error rate is still there. And people reach a result that's one side or the other of the reference range all the time in every scientific discipline,
So let's
even
have-
in DNA.
Let's have somebody that we all agree on look at this and say, you know what? This is one of those rare instances where it was a close call.
I think that's.
Or this expert may say, this is not a close call. This examiner made a bad mistake. So let's get that far.
Is that a commission issue or is that a law enforcement issue?
It's both.
Prosecution. I'm gonna disagree with you. I don't think that's a commission issue. To re-examine evidence of a particular case. It's not.
It's checking the quality of the work, I think, right, of that analyst.
But it's a particular, if it were, well, anyways, no, I don't.
I think we got 2 hands here and 1 on the WebEx. Jessica, would you like to go first?
Hi, sorry, still difficult to hear. Well, can we ask, since error rates came up, I have a couple questions, but one, can the New York State Police give us an error rate?
So I think we want to clarify I'm defining what an error rate is. So coming from the comparative disciplines, having one examiner, because this is judgment of expert folks based on their training, education, experience, they have opinions. There is a threshold, and the difference between inconclusive and I'm calling it a conclusion can be, as we've seen by our 9 out of 51, that both can be reached and one does not negate the other. Where one says it doesn't quite meet the threshold for an inclusion for me, I'm calling it inconclusive, and someone else says, I think there's enough here and I'm calling it conclusive. Is that an error or is that a difference of opinion? One is not saying it's not from this gun and one's saying it is from this gun. One is saying, well, I don't have sufficient characteristics to make this call. They're not calling it a elimination. So this happens and it's it's not an error rate, in my opinion. But if you want to call,
I agree with part of what you said. Sorry, I didn't mean to cut you off. Go ahead.
No, sorry, go ahead, Jessica. My apologies.
No, I was just going to say, so I think your answer is no, you don't have an error rate, which is in accordance with what I've seen, right, in the published studies. But 2, you're right, it is a difficult thing to come up with an error rate with something like this. Something studies, and tell me if you agree or disagree, but one thing that does seem like there's some consensus on is that inconclusive conclusions are often, more probably than not, actual exclusions. So that's part of the concern here. I understand your lab reached an inclusion and Onondaga and uninformative. Can I ask, I have two more questions. One is about your particular protocols for what criteria constitutes an uninformative or inconclusive versus an exclusion. And then the second question is going to be about the notification that occurred, which I know we spoke about at the beginning, but I want to return to that. But could you first tell me what criteria underlie a conclusion of uninformative or an elimination or exclusion?
I think Ms. Creso answered that question already, and I would give you the same answer. We follow, we have published NICLAC report wording, which also includes the theory of identification. I can't really do anything but rehash her answer. I would agree with her answer.
Wait, I'm sorry. I was asking what are your actual criteria for when you reach an elimination? I may have missed it. I'm having problems with the audio, but I didn't. So you're saying you agree with Onondaga's criteria? Is that what you just said?
Yes, we agree.
Okay, I see. I'm sorry. Okay. Okay, thank you. And then the second question I had was with respect to the actual notification. So please help me understand. The New York State Police did provide a notification letter to the commission, but when was that?
That was within whatever and I apologize, I don't have it with me. So that notification was provided within the permitted time frame or the appropriate time frame to say, here's what.
I think we may have that information.
Yeah, if you have the letter.
Might be easier, yeah.
Yeah.
I just gotta find the page.
Yeah, I don't have the
What's the
letter
date?
exactly, but it was presented in the June 2021 meeting.
Okay.
It was included.
Why the delay in informing the commission?
Want me to answer this?
Go ahead, Brad.
Okay. Again, I think that Director Wickenheiser addressed this in the last meeting. Can you hear me okay, Counselor? This was on the end of your report because we did not consider the difference of opinion to be a quality event. The quality event we had was inadvertent retesting, and that was included on the end of your report. The person responsible for that inadvertently left 2 notifications off of that report. Once we became aware that those were left off the report, we reported them.
Can I follow up on that?
Sure.
So, if I may, that's actually what I wanted to ask you about, because a lot of this discussion has been on the cause of the disagreement, but I'm more concerned about the systematic failure that you're discussing with respect to not catching the retest, and especially concerned with the language, I want a better result. That kind of language to a lab that's based upon a foundation of unbiased approaches is concerning. That should have rung bells. So my question is, if you've given any consideration to how that occurs in an environment that's predicated on an unbiased approach.
So you're asking me about a decision that this police officer, correct? I didn't make that decision.
Was there any investigation on your part as to how that happened? Anything else about the conversation? Anybody spoken to about it?
As I said, I called the detective. I knew that detective was brand new in the crime scene unit. He told me he didn't know better. And we've never seen this before.
But that conversation was with somebody at the state lab who then heard it and then went forward with the testing, correct?
No. This was after the test, after this issue came out that we inadvertently retested.
So initially, when the police came to state police and said, we want it, I see. So when it came out, they said it was because we wanted to retest it. So initially, there was no hint of any disclosure to the state lab. There was no way for the state lab to know that this had been previously tested.
That's correct.
I
To address the labels, because this is my own miss, I made a decision. In hindsight, I could have made a better decision. But I made, based on what my examiner was telling me, that 2 of the cases had indications of having gone to the Onondaga lab based on labels, and she told me there was nothing on the gun box. It is not altogether uncommon for us to retest evidence, not to repeat testing, but one lab, I can think of an example. Nassau County Police Department had a homicide case. NYPD recovered a gun. Nassau, there was discussion back and forth as to whether we would get the gun from NYPD. They chose to do the comparison. It was an elimination, right? Albany PD later recovered a gun. That same evidence with labels all over it came to us to compare to a different gun. Based on what the examiner told me, we came up with an analytical plan to not intercompare the two cases, the crime scene cases, the assault and the homicide to each other, but just to compare them to the gun.
But that didn't happen here. Like that clause from, you get a kit and it's got the markings, it's got labels on it. That what you caught with the Nassau and NYPD.
Well, I was notified of in advance. Part of my decision-making process, and I was a police officer for 18 years, 13 years before my 24 years in the lab. I processed my first crime scene in 1988. I would never have thought that a police officer would resubmit evidence. I mean, it boggles my mind. And again, I'm not making excuses for him. You'd have to speak to him directly. This is what he told me. I didn't know better.
So there's no standard operating procedure with respect to when evidence is received, and there's any hint of it being tested previously as to what should.
We do have a policy. We do have a policy. We do not retest.
Okay.
So hence the non-conformity that there was inadvertent retest.
Right, but they didn't know that there was a retest. There's nothing with respect to markings, labels, or in other words, to conduct an inquiry when there are these warning signs that this could be happening. I understand you have a policy not to retest, but
we had the policy before. We didn't see the markings, so that was a mistake.
Okay.
So had the person who was looking at it, there's markings on it. We normally do have markings on it. Did not see and recognize it. Should have seen it. Should have recognized it. Should have not done that examination.
And you're comfortable with that? Was that they failed to see it?
Yeah, we had a full investigation into that, made improvements, and made sure that our folks, because you're just not normally looking for it, even though we have that policy. We missed it.
So Ray, by saying they did not see it, that was on the firearm. You saw the markings on the fire components, but not on the firearm.
The evidence
So
from the
you
two
felt-
crime scenes, the homicide and the two crimes against person, homicide, and I believe the other one was an assault. All the evidence that we had was projectiles, and then this gun, which according to our submission form, which all we knew at the time, we didn't have the information that the DA provided, that it was called in as being found next to the porch. It was just a found gun, and that's what we operated on.
I see. So the analyst saw the markings from the projectiles.
Well, and on the packaging for the projectiles.
Right, but not on the
How they
firearm.
related it to me was that these two cases had markings from Onondaga and the firearm didn't, which was incorrect.
So
that's what was related to me.
Gotcha.
Yeah, so for the record, we have to clarify what I said previously. There was some delayed notification because we had a quality person who had a couple of different nonconformities on their desk. They departed for another employment. And essentially this should have made our year end, did not, because the files were on their desk. When we found them, we then report them. So there was a delay in reporting. So my mistake.
I just had a question going back. You said you did this quality assessment where 51 cases were reviewed with another laboratory. 9 of the 51 you ended up with the discrepant results again. Was there any analysis done to demonstrate a bias on one side or the other? Like your analyst always had an inclusion where the other outside analyst always had an inconclusive, or was it a mixture of the different results?
Brad can probably speak to that, yeah.
In every case where there's a difference of opinion, the external lab examiner made a conclusive conclusion where one of our sergeants at the time was a member of staff section.
Excuse me,
They called.
we need you to face the
Okay, I'm sorry.
speaker.
So I'll repeat that. In every case, one of our former examiners had called inconclusive, and the reviewing analyst examiner had made a conclusive determination, either inconclusive or identification.
So there has not been a specific reanalysis of her work?
There has been.
I'm glad you brought that up, and I owe this body an apology. For the last meeting, we were focused on this meeting and Brian History's complaint. Sometime after the meeting, looking at documentation, I realized later in 2019, we did review all of her bullet comparison cases, firearms ID, conducted in 2019. Oh, it's okay, I'm sorry. So we did, later in 2019, not connected to this meeting, we did have occasion to review all of this examiner's cases involving the microscopic comparison of projectiles. In the process, we actually captured all of the cases that this contract examiner had reviewed for her involving projectiles. These cases were split up between the technical coordinator and a second qualified examiner. They recalled evidence in 2 of the cases, and at the end of the day, they found no technical issues. They agreed with the conclusions, and we felt we typically review for a year, at least in my sections, and unless we find a loose thread that we can pull on and go further, we stop.
And so if I could just add to that, besides actually re-examining those cases, this individual also went through independently AFTE, which is what the Association of Firearms and Tool Mark Examiners, did a practical examination and a written examination and became AFTE certified. So in terms of actually testing their capability, look back at the cases, actually demonstrate their proficiency in terms of both written and practical, and we were still pursuing the blind test, of which we couldn't complete it due to the accident and medical situation.
So 1 year's worth of her work was re-examined?
That's correct. Well, it was, to be clear, the examinations occurred in August. We did 2019 year to date. The case that caused the re-examination, which was a question and peer review, was the last case that she worked. Because due to the accident, she went on terminal leave or long-term leave and then separated service.
Do you know how many cases in that review involved her testifying in court as to a match between a firearm and a projectile?
I do not, sir.
Okay.
I have a quick question.
Sure.
On any of those reviews, was the tech lead at the time that attended the mediation session, did that person do any of the reviews?
The reviews were split up between that person and a second qualified full-time NYSP examiner, not the contractor.
Additional questions? Just want to clarify that the commission heard in 2021, okay, from the disclosure about from the state police.
Correct. And that was about the inadvertent retesting, not about the.
Okay.
Because that's where our non-conforming work is.
All right. I think we have no more questions. Thank you.
Thank
very
you.
much.
Thank you.
Thank you.
Thank you so much.
Yes, we have a request for a 5-minute break. And I see heads nodding, so we'll say yes. Let's take a 5-minute break.
Catherine, you can just mute, and we'll just keep rolling, that's fine. So don't need to stop the stream.
Do.
Okay, I think we'll get started again, just so we are definitely cognizant of the time and the rest of the agenda that we still have, so we can get started. Colleen, we just have one more legal
Yes.
matter and then I can take over.
Yep, in response to the request from Dr. Marciano at the March 2024 meeting, Special Counsel Natasha Harvin has provided a memo to the Commission outlining their duties and obligations. Is there discussion regarding the memo?
Just a thank you. It seems like we're gonna need to take it on a case by case to get interpretation, but I appreciate it.
I think that it's difficult to envision what future questions will come before the commission.
Yeah.
And how that affects the, actions of the commission, but, I think the memo references all the applicable legal, statutes and regulations. And we can revisit those at any time the commission feels it's necessary. Back to Dr. Dooley.
Thank you. So I just wanted to speak under new business. Our first item is the NIST interagency report. This was released in early May, literally the week of the DNA subcommittee meeting. And it's authored by the expert working group on human factors and forensic DNA interpretation. The title of that report is Forensic DNA Interpretation and Human Factors, Improving Practice Through a Systems Approach. The subcommittee also recognized the report at their May meeting and are reviewing for discussion for their August meeting. They've also asked the Biological Sciences Technical Working Group to review the report and provide feedback for the August meeting. So at that time, the subcommittee will advise the commission on this matter.
Okay.
Yes, sir.
I know we're stretched for time, but we kind of skipped after the break. We kind of skipped what we were talking about before the break.
Voting on independent.
Are we going to have as Pat suggested, are we going to have an independent review of the evidence?
I think that there's a couple things to consider. I think the commission is free to make recommendations, but I don't know that we are not in control, or from what we heard that the labs do not have the evidence, or we don't have the ability to collect the evidence. I think also we could recommend that certain actions be taken. I'm not sure we have the ability to actually take that action unilaterally.
Just what would be the goal of having that done at this point? Because as of right now, they've said that all the evidence that the one person had looked at has been reviewed for that 8-month period. And moving forward, I don't see, they've done proficiency testing, both have shown proficiency and that one investigator's left.
From my point of view, the goal would be to do a more extensive review of her caseload.
Beyond the 1 year?
Yes.
Well, that would be my question. The commission could only recommend, and who would we recommend to?
Well, I'm not going to recommend anybody, but I think certainly Office of Forensic Services would be qualified in identifying a firearms examiner independent of this entire situation.
Who pays for that too, also, I think would be a good question for the commission to say, as if we make that request, who does the obligation fall on?
State of New York.
Who, I mean.
Now all of a sudden we're strapped for cash?
I'm just.
No, I think we're back to who's in possession of this material that would be reviewed?
I believe the Utica Police Department has.
Okay, so who has the authority to ask them
I'll
to
take care of
submit it to a third party and pay for it?
And who would be the third party? I guess I'm a
Well,
little
Office.
concerned with that because anybody who just watched that meeting, which would be all of the labs in New York State, and then plus, we want, if we truly want it to be a blind test, right, we need to recommend somebody who really has no knowledge of this at all, so.
Yeah,
I'm not saying I'm against it, I'm just saying I don't know
Somebody
where you
from-
go from here.
Or somebody from outside New York, somebody from the neighboring state,
How about
somebody
you?
from the FBI. Maybe the FBI will do it as a courtesy, and there won't be any cost.
So then when we get the results back, what if the
Depends
third
on what the-
party agrees with?
Depends on what the results are. If the results are, you know what, this bullet came from that gun, then Utica's got a problem with the integrity of their conviction because they convicted the wrong guy. If they come back and say inconclusive or it's not the gun, then I think we have to do a more extensive review of our casework.
Just a clarifying question. I thought it was mentioned that the gun had nothing to do with the conviction.
That's
Was not used at all.
that's correct.
Okay.
That's what I was told by the Utica DA.
But that doesn't change the scope of the criminal investigation. If evidence isn't used, that's only part of it. Because very often defendants take pleas of guilty, cases don't go to trial, evidence doesn't get submitted. It's the process and procedure, I think, that from our standpoint is more important than whether the evidence was submitted in that particular case.
We have a responsibility as the commission for the labs and the reports and the analysis that are conducted. And my point being that if none of this weighed into a prosecutorial decision.
The commission, I don't think it has the authority to conduct testing or cause testing to be conducted. That has to be on the police department that possesses the evidence. I mean, I think that there could be a motion and a recommendation to, notify them of what the commission thinks is appropriate. But I don't think the commission is empowered to evaluate, or to do the evidence testing, which they essentially would be doing. They would be acting as even though they're not physically doing it, they would be causing someone to do it for them, as their agent.
Well, we just heard from the state police, I believe, that it would be their policy if they knew it had already been analyzed, not to reanalyze it because of not wanting to get into the discrepancy, right? So if we were to make a recommendation regarding laboratories, it involves two labs, Onondaga and the state police lab, that we could recommend to those two labs that in the spirit of the mediation that has already been done, that they might want to consider having the evidence sent to a third-party laboratory to resolve the issue.
Onondaga already had it examined by a third guy. Onondaga already had it examined by a third guy who said, you're right.
Right, and it agreed with them, so.
But that was their own employee, right?
I don't
Oh,
think
yeah,
it was
fine.
exactly the same thing,
The guy worked there 7 years.
but that would be,
In hindsight, it probably should have been somebody completely independent. But
right.
I mean, I know who the person is, and
They seem to be able to request the evidence in order to do retesting. We can't, apparently.
Well, I mean,
Yeah.
the commission is not
Not
a
an
lab.
analytical body.
Right, I mean,
It would have to go through one of the labs, was what you're saying, based on our request.
yes.
Yeah.
See, I don't, I think the commission's review is related to what has been done, not, I don't think they have that the commission is independently authorized to pick evidence to require certain things to be done with things not in our control. That evidence is not under our control. We don't have, the storage here. I think it would be, making a recommendation would fit within the commission's purview of, oversight purview.
look, there are those in the New York State legislature that want to completely revise and disband this commission. You know that, right? We all know that. Passed in the Senate. I don't even want to talk about that bill. The bill would eviscerate state lab. So here we sit. We refer this to the Inspector General. I'm still trying to find out somebody the Inspector General interviewed in connection with this case. So if we don't have any investigative authority, which according to the memo that we got coincidentally for this meeting, we do, let's do it ourselves. Let's find the money to pay for an independent look at this, get to the bottom of it, and let's move on. That's my motion. Whatever, and nobody want to vote it down, fine.
I'll second.
Second,
All right, so,
not the voting down part. Second the motion.
all right, so,
I'm moving that we, if able to obtain this evidence, and I will make effort to obtain the evidence, that we refer it to an independent forensic firearm examiner outside of New York State and have him or her submit a conclusion to us as to the results that they discover in connection with the evidence, whether or not the murder weapon or the murder bullets were fired from the gun that was recovered.
And I second.
Can we have discussion about this? About this motion before we vote on it?
yes,
Okay. So respectfully, to what end? Because we had testimony just a couple of minutes ago saying that the reason why the very new law enforcement officer in Utica submitted it to the state police was because allegedly they didn't like the result that Onondaga had reported. What I'm worried about is that when there are other disagreements down the road of testing, and I'm not saying that there's a mistake in another lab, because I'm not aware of another DNA lab getting work that my DNA lab may have worked on or something like that, but whatever the situation may be where there's dissatisfaction with the result that we report, and I'm really speaking now about being a scientist who is working on cases that are of a forensic nature, but our job as scientists is to do the science. But I think that all of us in forensics have encountered situations where someone to whom we have reported a result may not have been very happy with the result that we reported. And we as scientists, I believe, try very hard to say, well, this is the science and this is the result, and give us a reason to go back and do additional work where the science wasn't good. So I guess my question is this still trying to determine whether science wasn't good in one of the two laboratories, but because the retesting already happened? So do we want to do more retesting? And what if we end up with the same results of inconclusive here and, well, I don't know. So
Here's why I think this case is different, Lydia. It came to our attention several years ago, and we were all under the impression that it was being investigated by the IG. It wasn't. That's a mistake on our part. We should have a.
May I?
Yeah.
We have information that the
I say
there
AG,
was-
I meant IG.
the Inspector General considers the matter closed, not that they did not investigate.
I've asked everybody involved in the case, Justine, Ray, the lab directors. Were you interviewed by the IG? No, nobody's been interviewed by her.
I don't know that reflects what I heard. I also know that often individuals are asked not to speak if they've been interviewed about it.
But if we refer something to the Inspector General, it rises to that level.
We did not make the referral. The commission did not make the referral, is my understanding, that the referral came from somewhere else. And often the Inspector General will provide a response to the referral entity after a matter is closed, but the commission did not make that referral.
Either as it may. My understanding was it was referred to the IG. IG did something double secret that we're not allowed to know about, even though we're the ones that asked them to investigate it.
But we were not.
This to me is a serious matter. It should have been disclosed a long time ago. It should not have been brought to our attention by Brian Gestring. Now that it was, I want to make it right. I want to make sure that there's nobody that has been unlawfully detained or incarcerated as a result of bad results. And I think we're entitled to have this brought to a conclusion. If the report comes, whatever the report says, we'll act upon it after we get the report. It's a minimal expense. I'm racking my brain in 20 years on this commission. I'm sure we've done it before in terms of referring things to other people. But we're either a commission or we're a rubber stamp. That's my opinion. I think we're a commission, and we have an obligation to get to the bottom of what happened here.
I have a comment. So if the underlying goal here is by having it retested is to just have more of that analyst's casework reviewed, then why don't we just recommend that be done?
Fine with me.
I mean, and not bother with the retest. I don't know what that's gonna really gain us to have that particular evidence retested. It's already been looked at by multiple people. And
I like the idea. I'll take that as a friendly amendment, and I'll.
So
Good idea.
the motion would be.
The motion would be
make
to
a
ask the state police to voluntarily review 5 years of this, I know it's a woman's, of this woman's casework.
Is there discussion on that?
Do we want any kind of impartiality though? No.
Well, I'm now gonna be a devil's advocate and say, if you think the mistake was made in the state police lab, why don't you think the mistake was made in Onondaga?
Yeah.
Well, I think an inconclusive isn't as damaging as.
Yeah, but he's arguing that an inconclusive is just as damaging because it says that a gun that was used.
Does anybody in this room think that freaking bullet that killed a guy came from that gun? Of course not. Their own tech review guy said it didn't come from the gun. And I know we're gonna go through the kabuki dance of, well, he said Onondaga did a better job. Okay, Onondaga did a better job because Onondaga was right. Okay? So.
Well, police lab says it came from the gun.
So there's a guy wrongfully convicted in Utica. Let's get to the.
I'm just saying, I don't think why do you think the error happened at the police lab? Because she was nervous and didn't make a good case? I don't think we have evidence that an error was made either place. One, they've reviewed a year's worth of work. Two, they had a third-party reviewer, and there's an error rate in the science.
I'm confused. I mean, are you adding for emphasis that someone was wrongfully convicted, or do we think that there's a possibility that someone could have been?
I don't think that gun had anything to do with the case. I think some unscrupulous member of law enforcement didn't like the result he got from Onondaga and sandbagged the state police lab. I think the state police lab should have immediately disclosed to this commission that there was a serious disagreement about the efficacy of that evidence. None of that happened. So we're in this conundrum here today. Now the entire science is under attack, and mark my words, you're going to see a court case within the next 6 months where the discussion that we've had in the last several hours is going to be cited to a judge, guaranteed, in the state of New York. Be that as it may, I like the idea. The only thing I care about is that the truth get out, and that if this woman made a mistake, whether she was nervous or not, that let's review her work. Let's feel comfortable and say this was a one-off, as Ray said. This was just one of those rare instances where the evidence is so close that reasonable people could disagree. Or was it more serious? Was it an issue of competence?
And her lab director is confident, having reviewed a year's worth of her work. That's the answer we got. It's not for us to decide whether a year or 5 years or 10 years.
I thought he said 8 months.
I thought he said.
But I don't know how many times I don't know how many, I thought he said 8 months, but I don't know how many times in those 8 months she made a conclusive comparison for the result.
He told us he found no discrepancies, no errors when her work was reviewed.
I think I asked him how many times she testified. He said he didn't know.
He's still here.
Trust me, my memory is good. I'm right.
So if someone would like to ask a question, they could. I don't think we need to go through the
No,
whole.
we don't.
Well, is there a motion on the floor or not?
Yes, my motion, I've amended my motion based on Beverly's comments to ask the state police to voluntarily agree as a request from this commission to cooperate with this commission and review 5 years' worth of this analyst's work, with particular attention focused on cases where she made matches and where she testified in court. That's my motion.
Yes, sir.
So you're saying positive identification cases?
Not limited to those, but with emphasis on those.
Or
If we're reviewing 5 years of casework, it's regardless of the,
I understand.
or asking them to review 5 years
I
of
understand.
casework, it's regardless of the conclusion, so I think.
But I would like, when they report their data to us, if the motion passes, to have a summary of the times that she testified and what she testified to.
is there a second to that motion?
Second.
You get a second? A second.
And a second.
Can I ask another question? I'm sorry, because I'm not
Yeah.
comfortable voting yet at this point. When you say review, the evidence, the case file, a tech review, a verification, the word review is very broad in a forensic lab. So what?
I trust your expertise, Michelle, to define it, review. If I was reviewing a prosecutor's casework, I would go through their files, check their dispositions, look at things like that. I'm not qualified to say how I go about it. To me, it would be, here are the cases that she worked on. I'm going to start with the cases where she made positive identifications. I'm going to review those. I'm going to have those reanalyzed by my tech leader. I know it's going to be labor intensive and
They
inclusive.
don't even have the evidence.
No, they don't. Right.
They don't even have the evidence for some of those cases.
Would it,
How are
is
they
there
gonna do a reanalysis?
consistent with review protocols or?
That's what I'm asking. Can we respectfully request them to voluntarily do a paper review? I mean, a case file review. So where a qualified analyst would review a case file as opposed to the evidence.
Which could include images and things.
Right, absolutely, yeah. Firearms case files typically include images.
If you tell me that would satisfy my needs, then yes, so that's fine with me. I mean, I don't want to micromanage how they review this woman's work.
Consistent with how they did the review of the previous
Of the 1 year.
time period?
Yeah. Of the
Was
1
that?
That's fair, that's fair.
Go back further.
That is fair.
Additional questions, concerns, clarifications?
Can I reiterate the motion for,
Let's, yes.
for just logistical purposes and how we capture it in the minutes and make sure that it's followed through appropriately, is that Fitzpatrick has amended his motion to now ask the New York State Police Laboratory to voluntarily review 5 years of the casework of this analyst, including when they issue the report on that review, a summary of the times that this individual testified and what they testified to. That is the motion,
conclusion.
the conclusion, right, with the conclusion that she testified to. Is that, do I represent that correctly?
Yes.
Thank
Well, the
you.
type of review.
A case file review, a voluntary case file review is what I believe we have deemed.
All right. So, all those in favor, please say aye.
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 All those opposed? Any abstentions?
Abstain.
I heard one opposed and one abstention. Is that accurate? Given that, that motion will carry. We will present that.
Thank you, sorry.
All right. Now we will go back to Dr. Dooley.
Okay, so the NIST report, again, the subcommittee will advise the commission on this matter after their August meeting, once they've done a review. Any questions on that? Okay. We're going to move on to laboratory disclosure section of our agenda. We're going to hustle our bustle. First up is Onondaga County Forensic Toxicology Laboratory. This is the first item is an initial notification of a closeout of a report being issued with the trace oxymorphone that did not conform. An amended report was issued and a review of cases showed that no other reports were affected. The second item is the initial notification of an unacceptable proficiency test result. The laboratory reanalyzed the sample and obtained acceptable results. The lab has investigated and found no casework to be affected. The laboratory director has already taken the table. Are there any questions for the lab?
Just have the one question I asked earlier.
So go for this.
Same question.
Okay.
Do stakeholders include the defense community, or does it end with the prosecutor, and do you rely upon them to communicate it to the defendant in that case?
So we consider the stakeholders to include the defense as well. We did not have the defense contact information in this case, but we went out of our way to confirm that they were notified.
Thank you.
Any other questions? All right, moving on. Thank you. We have the Nassau County Office of the Medical Examiner Division of Forensic Services. The first item is a notification of unexpected results from a 2023 Q3 DNA proficiency test. These results relate to certain aspects of testing that the analyst did not perform and therefore did not report a result for. Again, this goes back to the discussion we previously had that this is an unexpected result and needs to be disclosed to ANAB. The second item is a notification of an inadvertent custody transfer of the laboratory's information management system. The laboratory received a new version of their information management system and are continuing to investigate the issue. Are there any questions for the labs? Folks virtually, if commission members virtually, if you do have a question, feel free to speak right up because I cannot see the little hand icon on the screen. So just interrupt. Thank you. Hearing none, moving on. Nassau County Medical Examiner Division of Forensic Toxicology. This is the first item is the notification of an unexpected proficiency test result involving acetone. Quantitative reporting of acetone has been suspended while the laboratory investigates the issue further. The second item is the closeout of an analyst being removed from the drug screening that was initially discussed at the March 10th, 2023 meeting. The analyst was retrained and no deviations from policy and procedures occurred during the 6-month monitoring period. The analyst has been authorized to perform that screening method. Do we have any questions for the labbers on this matter? All right, moving on. New York City Office of Chief Medical Examiner, Department of Forensic Biology. This is the notification of unexpected results from several proficiency tests. These results relate to the unexpected results due to analysts did follow the procedure, but was still deemed an unexpected result, and therefore it needs to be reported to ANAB. Are there any questions for the lab? Do you have members available virtually?
Yes, I have questions.
Catherine, if you could elevate them.
Afternoon.
Can we just, okay, hi Craig, good to see you. Jessica, go ahead and ask.
Hi, good afternoon. So I had some questions about what exactly I was looking at with these PT results. Dr. O'Connor, is this the first batch of PT results from the new Progeno PT test or proficiency test?
Sorry, this is Tiffany Vasquez, the technical leader.
I'm
No.
sorry.
Yeah, no, these are from our standard proficiency tests. We're not participating in the ProbGen proficiency test at this time.
Wait, this is from what batch?
These are from standard proficiency tests that we typically do for our DNA testing. We are not doing a separate ProbGen proficiency test at this time.
Okay, that answers some questions. So I was unclear. There seemed to be a list of, I don't know, 10 or more unexpected results. Can you explain exactly what that means? Does that mean how many analysts did this involve? Was it the same analyst? Was it different? Does this mean they failed? Does this mean they passed because they followed laboratory protocol, but still didn't get the right result in terms of calling an allele? It's sort of hard to wrap one's head around what I'm actually looking at. Could you help us understand?
Sure. So each of those lines is for a separate analyst. All of the results were passing results. They did follow laboratory protocols. The majority of the unexpected results were, for example, we may have had an unresolved allele, so it was not called by our analysis software. So by protocol, we would mark that location inconclusive because we can see that there's an allele there, but we don't have an allele call for it. And so the proficiency test vendor would list that as a difference from their consensus results because we did not provide a result for that location. So we would note that as an unexpected result for the vendor, but yet they did follow our laboratory protocol and we would deem that a passing result. So that was a number of the examples that were on that list. And then there were some similar ones as well.
And just to add that each line is for an analyst, and the analysts we have are paired together. So we'll typically have a technician, a reporting analyst, and a technical reviewer or supervisor that are all paired together. So each one we get a separate line. So although the number of analysts there, it may not be that many proficiency tests.
So a few questions. In a number of these, the laboratory reached an uninformative conclusion through the use of the STARMAC probabilistic genotyping program. But I didn't see, and I suppose I could go to CTS's website and check against the test, but what is the right answer versus what is the actual LR you all got? Does that make sense? Like, did your
CTS does not ask for CTS does not ask for a likelihood ratio. They just ask for a conclusion. So it depends on the wording of the conclusion that they're asking. Some of the proficiency test vendors will say, can the exemplar that they provided be a contributor to the mixture? Some of them give you an option of included, excluded, or inconclusive. So it really just depends upon what question is being asked. There were several of the tests where the based on the likelihood ratio for the comparison sample, it fell within our uninformative range. So therefore, the analyst marked it as inconclusive. So that's what it is. But the CTS vendors aren't looking for, or the proficiency test vendors aren't looking for a likelihood ratio to be reported.
A simple sort of binary in or out.
Yes.
But you actually didn't reach an in or out conclusion for a bunch of these, but that's still not regarded as an incorrect answer. Just
well,
you know what I'm saying. So if you
I mean it's because the sensitivity of our instruments. There are times where an additional allele or two may pop up. So then therefore, when we're calculating that likelihood ratio, it's giving a as expected likelihood ratio close to 1. So therefore, it was deemed as uninformative or no conclusions was reported to the vendor. So they are following our laboratory protocols.
I'm not sure this question makes sense, but have you done any further investigation with respect to the data. So for instance, if I think in a couple of these, you reported that a stutter peak was reported, but that's not the true result according to the test providers. Or have you explored, regardless of the test, what the effect on the likelihood ratio would be if that stutter was or wasn't included? Do you understand what I'm saying? Like where your results deviated from the expected results, did you go back and analyze what would have happened had you included that information that was ground truth known in your calculation? Does that make sense?
It does. Well, we have, I'll give you this answer. We have used the information from these proficiency tests in order to reevaluate our protocols. And we have been doing that. And we've looked into our stutter modeling, and we've looked into our analytical threshold, and the process is ongoing in terms of evaluating it. We've actually also adjusted our optimal amount of DNA that is being amplified to account for the extra sensitivity of the 3500s, since we went online with that to try and address that situation. During the validation of our probabilistic genotyping system, StarMix, one of the experiments that was done, the studies, was looking at the effect on the likelihood ratio of over or underestimating number of contributors. And in that study, we did see that with the overestimation, it tends to not affect the likelihood ratio of a major contributor or a distinct minor contributor, but might increase the likelihood ratio of a trace contributor. But that likelihood ratio increase was, for the most part, well below our uninformative range. So we are able to fall back on that information to know that even though that number contributor may be overestimated, we know what the effect of it is. But we are certainly in the process of evaluating that data. We are looking to come online with the next version of StarMix sometime this year if we can get the system validated. So all that evaluation is taking place right now.
And will that evaluation be part of the validation summary or work that you'll eventually publish or put out on your website?
For the newer version of StarMix, yes.
Okay. And I think my last question is, I understand you're not doing ProbGeno PTs now. Is there a thought to moving to them in the future, soon?
We have looked into it, and we are evaluating whether or not that would be appropriate to look into bring on.
But no answers yet.
No.
Okay. Okay. Thank you.
All right, thank you, Craig. Thank you, Tiffany. We'll move on now to the New York City Office of Chief Medical Examiner, Department of Forensic Toxicology. This is a closeout of the sample and misaliquot issue that was first disclosed at the March meeting. The laboratory has completed its investigation and no additional cases were found to be affected. They will continue to monitor the effectiveness of the 2 improvements that they did make during their process. Does anyone have any questions for the lab? All right, New York City Police Department Police Laboratory. The first item is the notification of an issue within the controlled substance analysis section. During the final packaging of the evidence items after completion of analysis, one item of evidence was unable to be located. The customer was notified and the laboratory has initiated a full review. The second item is the initial notification of an unexpected result on a trace proficiency test. The analyst followed the laboratory procedure for analysis and reporting of results. The laboratory has initiated a full review. I just want to make a mention, again, these are just the initial notifications. We have no idea what point in the investigation they are at. We will hear from them when they further their investigation. So with that in mind, do we have any questions for the lab? Okay, next up is the New York State Police Crime Laboratory. The first item is the notification and closeout of lost evidence in the firearms section. The item had already been determined to be unsuitable for examination. An investigation was completed and corrective actions were implemented. The second item is the initial notification of a serology retest result that was not consistent with the original results. The lab has conducted an investigation and retested additional case assignments that came back consistent with the original results. The laboratory considers this event to be closed. And the third item is an update to a disclosure regarding an unexpected results in the seized drugs proficiency test that was discussed at our March meeting. The laboratory performed a root cause analysis and implemented corrective actions. However, an internal proficiency test was given to the analyst and was deemed unsuccessful. The analyst has not performed casework since December of 2023, and the laboratory is attempting to identify additional factors contributing to that issue. Are there any questions for the lab? Hearing none, we'll move on to the Niagara County Sheriff's Office Forensic Laboratory. This is an initial notification and closeout of work that has been halted in toxicology due to an out-of-service instrument. The instrument was repaired and a performance verification was successfully completed. Do we have any questions for the lab?
Only the comment that the lab, this quality systems manager, who's now interim director.
Yes.
His performance is an improvement from what we've seen in the past.
Comment noted.
I mean, the quality of his response and how he dealt with the issue is far less defensive and more productive for the laboratory.
Any other questions or comments? All right, Onondaga County Center for Forensic Sciences Laboratory. This is an update to two of the topics that were discussed at the March meeting. The first topic is regarding an unexpected result on an ignitable liquids proficiency test. Since the March meeting, the laboratory has reviewed 26 cases and found no cases to be affected by the issue that was seen in the proficiency test. The second topic is regarding the friction ridge detail that was not observed and or preserved. Since the March meeting, the laboratory has found an additional 3 cases in which friction ridge detail was not observed and or preserved by the original analyst. Do you have any questions for the lab? This is not a closeout. This was just an update as to the status of where they're at. When there's a closeout and a determination, I'm sure we will hear about it in that meeting. But in the meantime, are there any questions for the laboratory? All right, Suffolk County Crime Lab. This is the closeout of an issue discussed at the December 2023 meeting of missing evidence. A case file review was conducted for crime scene submissions with trace evidence, and no other cases were found to be affected. The procedure manual and lab-wide quality manual have been updated, and crime scene response members have been trained regarding proper packaging. Any questions for the lab on this matter? All right. We will move on to the Suffolk County Office of the Chief Medical Examiner Toxicology Laboratory. The first item is an initial notification and closeout of an issue where the benzodiazepines were incorrectly recorded between 2020 and 2022. The laboratory determined that the issue was due to similarity of the names in the analytes and abbreviations used in the laboratory prior to ANAB accreditation. Amended reports were issued to the medical examiner. The second item is an initial notification of an unexpected result of the ethanol proficiency test. The laboratory determined the cause to be an issue with pipetting, and the analyst was retrained. The analyst has not performed any casework, and therefore no cases were affected. Do we have any questions for the lab? All right, hearing none. Westchester County Department of Labs and Research Division of Forensic Science. The first item is notification of an unexpected result from several DNA proficiency tests. These results related to the unexpected results due to the analyst following laboratory procedures and the QAS requirements. The second item is the closeout of an unexpected result on the biology proficiency test first discussed at our March meeting. The laboratory investigated the issue and updated the proficiency test requirements for the senior forensic scientists to be more representative of their day-to-day activities. They have also updated their biology and serology manuals. Any questions for the lab? All right. Westchester County Department of Labs and Research Division of Forensic Toxicology. The first item is an initial notification and closeout of evidence transfer and misidentification issue. This was identified prior to a report being issued. Staff were reminded of the importance of examining item numbers during evidence intake and testing and reviewing procedures prior to completing their work. The second item is the initial notification and closeout of a blood kit with a specimen that was set for disposal. The laboratory accepts expired, unused blood kits from agencies to dispose of. So during the disposal, a kit was found to have a blood sample inside of it. The laboratory notified the agency and it was determined that no toxicology testing was needed. Do we have any questions for the lab? All right, Erie County Central Police Services Forensic Laboratory. This is an initial notification and closeout of an unexpected result on their fire debris proficiency test. The analysts will be retrained and complete an additional proficiency test following retraining. Any questions for the lab? And next up, Westchester County Department of Public Safety Crime Lab. This is an initial notification and closeout of an unexpected result on a 2023 mobile device proficiency test. The lab investigated and found the issue to be a transcription error. Are there any questions for the lab? All right, we trucked right through those. Thanks, guys. So I just want to say thank you all for your participation today. The next meeting on the Commission on Forensic Science will be September 27th of 2024, location to be determined. Do I have a motion to adjourn? Beverly, motion. Epstein, seconds. All those in favor, please say aye. Aye. Any opposed? Abstentions? Thank you for the music, Fitz. We are adjourned. Thank you.
You're dropping a hint where I want the meeting to be.
Thank you. Have a safe trip, everyone.
Thanks, everyone.